Good afternoon, everybody. Well, it's good afternoon to folks on the East Coast, and good morning to everyone else. My name is Raymond O'Dane, and I am an attorney at the NAACP Legal Defense Fund. I am absolutely delighted to welcome you to our conference, Immigration, Equal Protection, and the Promise of Racial Justice, a legacy of Jean V. Nelson. For those of you who may not be familiar with the Legal Defense Fund, we are a civil rights organization that was founded 80 years ago by Thurgood Marshall. We'll be talking a lot about Thurgood Marshall today and tomorrow. And the organization was founded to fight against racial discrimination in all aspects of American life. And over the decades, that commitment has led LDF to work and to shape jurisprudence in areas as seemingly disparate as education, capital punishment, criminal justice, voting rights, political participation, and employment. And today, we've all come together to talk about another area of American life that's been corrupted by racial discrimination, and that's immigration. This conference would not have been possible without the help of my co-organizers, Ellie Happel and Sarah Hamilton-Jung. So thank you for joining us. Thank you to Sarah and Ellie for all of their help. And we're really looking forward to a wonderful program. Ellie, why don't you introduce yourself?
Thank you so much, Raymond. And I just have to reiterate that it's been such a joy to work with the two of you. And welcome to everyone who's joining us on Zoom. We are extremely pleased that you're here. My name is Ellie Happel. I'm the Haiti Project Director and an adjunct professor with the Global Justice Clinic of NYU School of Law. The clinic was founded in 2010 by Professor Margaret Satterthwaite, and its name, Global Justice, is intentional, centering justice rather than the legal framing of rights. The clinic engages in spaces where institutions based in the global north are directly implicated in human rights violations. This includes Haiti. This includes the United States. For the past 7 years, the clinic has worked in solidarity with organizations monitoring Haiti's emerging gold mining industry and to promote Haitian people's right to self-determination. In addition, and more to the topic at hand, the clinic published a report arguing for an extension of temporary protected status, TPS, for Haiti, and I served as an expert witness in subsequent litigation. Raymond mentioned that for too long, civil rights and immigrant rights have been perceived as separate areas of social justice. Human rights, too, at least in this country, is often siloed, focusing on violations and abuses committed by foreign actors, atrocities that happen on other countries' soil. Justice requires that the human rights community sees police killings of Black people, family separation and loss of liberty simply due to where you were born, the atrocities and rights violations committed on American soil, and responds with similar outrage to those committed abroad. Human rights must recognize anti-Blackness, racism and xenophobia, and show up for racial justice, for immigrant justice, for Black lives, and for the lives of Black immigrants. The Global Justice Clinic sits within the Center for Human Rights and Global Justice, which is a co-convener of today and tomorrow's conference. And the Center for Human Rights and Global Justice is the hub of human rights research and scholarship, practice, and teaching at NYU Law. On behalf of the center, I welcome you all here. It is an honor to help make these conversations possible, and it really has been wonderful to work with Raymond and with Sarah Hamilton-Jung, who will take us from here.
Thank you, Ellie, and welcome again, everyone. My name is Sarah Hamilton-Jung, and I am an independent legal research consultant. I'm grateful again to have worked alongside my esteemed colleagues Raymond and Ellie, who have worked so diligently to prepare this conference. I became involved in planning this conference during my time at the Center on Race, Inequality, and the Law as a research scholar. And the center is just one of the many co-sponsors of this conference at NYU School of Law, along with APALSA, BALSA, the Civil Rights Clinic, the Immigrant Rights Clinic, the International Refugee Assistance Project, LALSA, the Racial Equity Strategies Clinic, and the Robert and Helen Bernstein Institute for Human Rights. Our co-sponsors at NYU and beyond NYU include the Center for Caribbean and Latin American Studies, the Gallatin School of Individualized Study, the Latinx Project, the 21st Century ILGWU Heritage Fund, the Haitian Lawyers Association, and the Migration Policy Institute. We're grateful for the generous support of all of our co-sponsors, without whom this discourse would not have been possible. We're also grateful to all our attendees who will be joining us over the next 2 days. We received over 700 RSVPs, and this number includes activists, advocates, lawyers, law students, scholars, and members of the community, and we look forward to engaging with you over the next 2 days. I'll now turn the time back to my colleague Raymond to share some brief introductory remarks.
Thanks, Sarah. So this conference was organized to commemorate the 35th anniversary of Justice Marshall's groundbreaking dissent in Jean v. Nelson. And it was a case that was brought by a group of asylum seekers from Haiti who alleged that the immigration policies targeting them were discriminatory. And the federal government took the position that the equal protection component of the Fifth Amendment did not reach those asylum seekers. The case made its way to the Supreme Court, and in 1985, the court issued a decision that's remembered primarily for Justice Marshall's dissent. And that dissent really marks a watershed in the struggle for racial justice in America. Justice Marshall argued that the Fifth Amendment did indeed protect these asylum seekers, and that dissent helped to lay the foundation for the work that many of us are doing today. I think that because of his searing and extraordinary life experiences, Justice Marshall appreciated that anti-Black discrimination against immigrants was just another expression of the same structural racism that runs through American history, and that the principle of equal protection was intended to combat just that. What I think Justice Marshall also understood is something that I think a lot of us understand, which is that, like almost every aspect of American law and public policy, immigration law and policy has long been an instrument of racial engineering, and that the struggle for racial justice for immigrants is part and parcel of the struggle for racial justice in America. Today, that struggle for racial justice has taken on a new dimension as the government goes after one immigration program after another, including TPS, DACA, and DED, just to name a few. And so the idea for this conference grew out of LDF's challenge to the Trump administration's efforts to terminate TPS for Haiti. I think that many people were surprised to see LDF, which is a legacy civil rights organization, engage in the TPS issue, which is commonly thought of as an immigrant rights issue. But what LDF understood immediately, and Sherilyn Ifill, LDF's Director of Counsel, will join us tomorrow to discuss this in more depth, is that it is absolutely unacceptable to afford the government any leeway to make any decisions based on race discrimination in any context. And that has long been LDF's position. That's the position that LDF emphasized in its amicus in Jean that it submitted back in 1985. And that position, that commitment goes to the heart of what I think this conference is about, which is that too often, like Ellie said, immigrant rights and civil rights are perceived as separate and distinct areas of social justice. And so we're coming together today, and we'll come together tomorrow to really interrogate this idea and to explore how the Trump administration's unapologetically racialized immigration policies are forcing all of us to grapple with it in old and new ways. We've also interrogated that idea in a 6-episode podcast series that accompanies this conference, where we talk about some of these themes in more depth. The podcasts are available on our website, and I definitely encourage you to have a listen. We, of course, have to acknowledge, as like with almost everything else, basically, this conference is taking place in the shadow of the most consequential American election of our lives. Now, I'm tempted to say ever. And it is really impossible to overstate the election's implications for the communities that we work to protect and the work that we do in the cases that we'll discuss. I'm going to turn it back over to you, Ellie.
Thank you, Raymond. We want to honor the lives of 2 activists and advocates for Haitian immigrant rights who died of COVID-19 in recent months. The first is Bernard Filame, co-founder of the Haitian Refugee Center in Miami. Filame fled Haiti at age 13 to escape the brutal dictatorship of Francois Duvalier, Papa Doc. He went on to help others who fled Haiti resettle in the United States. We also recognize the life of Jack Lieberman, an early member of the Haitian Refugee Center board. The Haitian Refugee Center was plaintiff in a number of lawsuits and central to community organizing. Attorney and longtime activist Steve Forrester said the following about Bernard and Jack. They were stalwart champions at a time when Goliath was running roughshod over Haitians' rights under our laws. Bernard and Jack were champions for dignity and respect for Haitians here and for justice, democracy, accountability, and human rights in Haiti. In addition to the gross mismanagement of COVID-19 at home and these tragic and preventable deaths, the US government has exported COVID to Haiti and to other countries via ongoing deportations. A number of deported people have tested positive upon arrival in Haiti and Central American countries. And in the past 2 weeks, there's been a severe uptick in deportation flights to Haiti. Instead of occurring twice per month, recently they've happened daily. The need to advocate for the rights of Haitian immigrants remains urgent, and the fight continues. We're honored to have numerous advocates who remain on the front lines of that fight with us today and tomorrow. Sarah, on to you.
Thanks, Ellie. So over the next few days, we'll look back in order to look forward, remembering Jean V. Nelson and the collective community resistance that rallied against the racialized treatment of Haitian asylees in the 1980s. Using this as a point of departure, the conference will center the experiences of Black immigrants to reflect on the tools at our disposal to reimagine the promise of equal protection for Black and other immigrants of color. So today's panelists will explore litigation and legal precedents as one part of the fight for racial justice. Panel 1 will begin with a discussion of Jean V. Nelson and how Justice Marshall's prophetic dissent heralded and influenced contemporary efforts to secure racial justice for Black and other immigrants of color. Panel 2 will then reflect on the relevance of Justice Marshall's dissent to various DACA, DED, and TPS cases. In tomorrow's panel, we'll explore other tools including activism, organizing, cross-movement collaboration, and transnational coalition building. I'll now hand the time over to Raymond, who will just provide us with a few housekeeping points and then lead us into our first session.
Excellent. Thanks, Sarah. So a couple of things. One is that panels 1, 2, and 3 of the conference have been accredited for CLE. So for those attorneys who are interested in applying for CLE, the materials and the forms are available on our website. And I think Ellie will post the CLE page on the chat. The other important part about the CLE and the affirmation is that we're required to articulate codes, which you folks who are seeking CLE credit will have to write in the affirmation. And so it is imperative that you listen for the codes during panels 1, 2, and 3, and that you write down those codes in the affirmation. The other thing is that we welcome and encourage questions from the audience. And please use liberally the Q&A function to ask questions of the panelists. If there are any questions about the conference and the CLE, we encourage you to put those questions to Diane Simmons. We will also put Diane's email address in the chat box. So that is it for housekeeping, and I am excited to move into the substance of the conference by starting panel 1 now. So the first panel is Discrimination and Dissent, the legacy of Jean V. Nelson. And we thought it was important to start with an in-depth discussion of the case because, like I said earlier, it helped to lay the foundation for much of the work that we're doing today. Again, Jean asked questions of discrimination and addressed questions of discrimination against Haitian asylum seekers. During the late 1970s and early 1980s, thousands of Haitians sought political asylum in the US. And that was in an effort to escape life under the Duvalier regime in Haiti. In response to that influx of Black and brown immigrants, the US government began to detain without parole immigrants who couldn't present prima facie cases for admission. And for everyone impacted, it was clear that this change in policy reflected just blatant racism. And so the Haitian community in South Florida organized and filed a discrimination lawsuit, which is how Jean began. And I am pleased, I'm more than pleased, I'm totally excited and totally stoked to have with us some of the people who were there to make it all happen. Some of the people who are closest to the Jean litigation in the 1980s. We have Ira Kurzband, who is now one of the foremost immigration lawyers in America. I'm not going to go over all of Ira's publications, accolades, accomplishments, and honorary degrees. I think his Wikipedia page does a pretty good job of that. I'll just say that Ira's treatise on immigration law, which is called Kurzban's Immigration Law Sourcebook, is one of the most authoritative, and Ira argued Jean in the Supreme Court. We also have with us Irwin Stotzky, who worked closely with Ira and Jean. Irwin is now a professor of law at the University of Miami School of Law. And for the past 3 decades, Irwin has represented Haitian and other refugees on constitutional and human rights issues in many cases, including several Supreme Court cases. He's also the author of many publications on Haiti and constitutional law. He's also a founding member of the Institute for Justice and Democracy Haiti, and the founder and director of the University of Miami Center for the Study of Human Rights. We're also very lucky to have with us Ninaj Raoul. Ninaj is a co-founder and community organizer at Haitian Women for Haitian Refugees in New York, which she co-founded in 1992 to respond to the needs of Haitian refugees and immigrants in the US. Ninaj is a Petra Foundation Fellow and a recipient of the Union Square Award. She's also the recipient of the Susan B. Anthony Award. Finally, we have with us Muzaffar Chishti, who's the Director of Migration Policy Institute at NYU. He's authored and co-authored several publications on US immigration policies, and he serves on the boards of the New York Immigration Coalition and the Asian American Federation. He's also a recipient of the New York State Governor's Award for Outstanding Asian Americans and the Ellis Island Medal for Honor. I'm sorry, the Ellis Island Medal of Honor. So I want to start with you, Ira. I want to start with you, Irwin, actually. If you can talk to us about what was going on in South Florida at the time in the run-up to the Jean case.
Thank you. I'm happy to be here. And let me just give you a little background. Raymond has mentioned some things that I think are important for the case. One is the fact that during this time, the most brutal regime, perhaps certainly in the Western Hemisphere, was running Haiti. It was the Duvalier family. Papa Doc served from 57 to 71. His son, Baby Doc, took over from 71 to 86. And they were reputed to have murdered, assassinated 60,000 people. They had a group called the Tonton Macoutes, which were private security force for Duvalier, who were loyal to him, and his response was to allow them to terrify people, kill them, steal their property. And a Haitian proverb sort of stands out as to what the feelings in Haiti were. Law is paper, bayonets are steel, which meant the rule of law didn't apply. During this period of time, I was sitting in my office when Ira Kurzband knocked on the door and came in. He was just graduating from Berkeley Law School. He was wearing bell bottoms, platform shoes, and in his Sheepshead Bay Brooklyn accent, had come down from New York, working with the National Emergency Committee, I think it was called the National Civil Liberties Committee, which had been headed by Leonard Bodine, a prominent human rights lawyer. And he interested me in working with the Haitians. And from that day on, I'm still working with Haitian refugees. This story continues. We filed a number of lawsuits during this period of time, Jean being only one of them. Just prior to Jean, we had filed a lawsuit called HRC versus Civiletti regarding deportation issues that affected 5,000 Haitians. The judge ruled in our favor in every one of the cases. As that case was being appealed, one of the most amazing immigration events in our history occurred. It was called the Mario Boatlift, in which Fidel Castro told all the people in Haiti who wanted to leave that they were welcome to. 125,000 people came over. It became a huge media event. The Freedom Flotilla boats from Haiti were picking up their relatives and bringing them here. They were processed and released.
Irwin, sorry to interrupt. You said Haiti. Do you mean Haiti or Cuba?
Oh, I meant Cuba. I'm sorry. Yeah, of course they were coming from Cuba. Another group, the Haitians, were also escaping Haiti. They came here in rickety boats. Many of them were incredibly overcrowded. If anybody remembers, the boats overturned, many people drowned. Some got here, And when they were captured, so to speak, by the INS, they were processed, but they were not released. They were detained. This changed the law because from 1954 through 1981, any refugees claiming asylum who got here were released pending after being processed, but not the Haitians. This was due to a Reagan task force, which concluded that we must stop these kinds of refugees from coming here by interdicting them at sea, by creating expedited removal procedures, and by detaining them. Not only did they detain them, they separated them, men, women, and children, and they moved them around all over the country in remote, culturally hostile areas without any attorneys. Big Spring, Texas, Rayburn, New York, Charleston, West Virginia. And this caused obviously great harm. Lawyers like Steve Forrester, who representing the individual Haitians, found that the hearings were being held simultaneously, 35 to 100 people at once. And they were being brought in the back stairwells of the immigration courts at double time paces, not being allowed to see the lawyers who were there to represent them for free. So we, on the night of June 10th, 1981, after 11 Haitians were illegally deported, we called the federal district court judge, asked for a TRO, drafted an amended, drafted a complaint, a habeas petition. 2 days later, redrafted it and it became an amended petition and complaint. And we then filed other proceedings and had a temporary restraining order. And then it proceeded for years. The case went on through 1985. And it was appealed, according to the government, more by the government than any case up to that time in US reports. The litigation was intense and never ending. And I have to say that if it hadn't been for Justice Marshall's dissent, the case would have looked like a common everyday case, because Justice Rehnquist's opinion spent most of its time talking about the procedures and very little of any time talking about what happened to the Haitians. So I can continue and talk now about some of the legal issues. Basically, at trial, 3 issues were up for a trial. One was the Administrative Procedure Act, because they had changed rules and had not published them and given us a time to respond. The Equal Protection Claim, which they discriminated on the basis of race and nationality, and a First Amendment claim that Haitian lawyers were being barred from talking to the Haitians and recruiting them, really, which was allowed, of course, in NAACP cases. After a 6-week trial, the trial judge ruled that the APA issue had been violated, released the Haitians, but said that the equal protection claim had not been met. We appealed on the equal protection claim. The government cross-appealed on the APA claim, at which point the argument took place, and we won on every particular ground. It was amazing. I do want to mention a couple of things. Rudy Giuliani, at the time that the TRO hearing came up, was the Associate Attorney General of the United States. He, behind the scenes, apparently was in charge of the criminal division, and the TRO, the judge in front of whom the TRO was taking place, the only Black American judge in the Southern District of Florida, was being investigated for bribery, which we didn't know at the time. And Rudy Giuliani was one of the lawyers who began to represent the government. So all this was going on in the background of the case. And so there was a lot of pressure, as Ira can attest, on everyone concerned, not only the Haitian community, of course, but the lawyers and everybody else. Now, this case came up from the bottom. It wasn't a case that was imposed by the lawyers. The Haitian community demanded that they be treated like human beings, whereas the government was treating them as less than human. And because of the Haitian Refugee Center and Father Jean Just, who ran it, and the Haitian community, this case went on and established an amazing principle under the tutelage, of course, of Justice Marshall. That is that immigration law is being constrained by the Equal Protection Clause. And as you just said, it led up to a number of other cases and issues and a variety of circumstances.
Thanks so much for providing us that background, Irwin. I want to bring Ira into the conversation. And Ira, I'd love for you to talk about kind of the substance of the case and the litigation and why it was so important for you, your team, the communities you represented to center the role of the Equal Protection Clause in all of this.
Okay, let me take first a step back and talk about what I think are the kind of the major themes of what we were trying to do at the time. The first issue really for us was how you approach this kind of case. As Irwin pointed out, this was not a case that was just conceived as a strategic decision. It was a case that came out of the needs and complaints, really, in many respects, of the Haitian community in Miami. So the kind of civil rights model, I think, of one in which you try to meet the demands of individuals who you're representing through the Haitian Refugee Center. And as Ellie pointed out before, many of these cases were brought on behalf of the Haitian Refugee Center because the center itself was the focal point of a lot of the political activity. And I think the first and most important lesson of John V. Nelson and the other cases we brought is the relationship between political organizing and legal work. Father Gerard Jean-Just was the head of the Haitian Refugee Center, and other people were involved. Raoul Jean Bart, Steve was involved, Jack Lieberman, Bernard Fils-Aimé. A large group of people in the Haitian community were involved. And the structure of what we were trying to do was not only to bring a legal case and to bring the issue of racial discrimination to the forefront in court. It was based upon political organizing within the Haitian community to bring out the issue of racial justice. And I imagine you're going to talk about that tomorrow, but there clearly is a link between both. And we felt the lawsuit was, in some sense, a secondary aspect, a part of a tactic, part of a strategy to bring out the larger issue of what we do in political organizing, to bring to the attention that Haitians were treated in a discriminatory way, both because of their nationality, but mostly because of their race. And the way that we did that is to compare and contrast them. As Irwin mentioned before, this was at the time of the Mariel Boatlift and so forth, where large numbers of Cubans were coming in, and they were treated differently. They were even treated differently in detention, to the extent that Cubans were put in detention. We pointed out, for example, at the Chrome Detention Center at the time, they were taken on field trips, went to the movies, etc. Haitians were crammed into unsanitary, harsh conditions at the Chrome Detention Center. So even on the level of who gets detained and who doesn't, but the major issue that we were trying to bring out was how Haitians were treated very differently than Cubans who were coming in at the same time, literally, in comparable conditions. That was the first point. The second is to focus on Haiti itself. That is, we never saw this case independently of the political conditions in Haiti. In fact, in each of the cases we brought, we had someone who would testify, an expert. Deborah Anker at one point, who teaches at Harvard, was an expert on the conditions and the treatment of Haitians. And we had other people who were testifying as experts on those conditions, with the idea that we wanted to show that Haitians weren't any different from the political spectrum than Cubans who were coming in. That is, they were truly fleeing persecution. Because from a political standpoint, what the United States was trying to say is, well, Cubans are fleeing communism and Haitians are economic refugees. That was what they used to say, economic migrants. They wouldn't even use the word refugees. So it was very important to focus on the political conditions. The third was kind of the national and transnational implications, something that I think Ellie touched on at the beginning, which was in this case, we made sure that this became a national issue. And it was very interesting, as I think we had talked previously, Raymond, when the Supreme Court ultimately issued its decision, Justice Rehnquist did something that was so peculiar in issuing the final decision. Normally, what a court would do after vacating the opinion below is say, we're vacating the opinion and remanding it back to the lower court. I have never seen a case other than Jean V. Nelson where where Justice Rehnquist or any justice said, they didn't say vacate and remand, they said affirm as to the judgment to remand this case to the district court. And why did he say affirm? Because this case had become not only a national issue, but an international issue. We had the Organization of American States that went to Chrome to determine how Haitians were treated at the time. So this became one of the first and one of the fewest cases in American history, if you think about it, where the federal government, before Trump, I mean, you know, there's after Trump and before Trump, but before Trump, this was literally the first case that we could find where there was discrimination by the federal government, other than cases in the District of Columbia. Most cases, if you think about, you know, challenges, and certainly LDF and all the challenges that were made, most of them were made involving state action, state law. Here we were, the first people coming forward and saying, no, it's the federal government that's discriminating based on race. So this became a very kind of nationalized issue, very focused on saying, why is the federal government discriminating against refugees based on race? The second part of that was also a transnational part, which was to show that the United States was helping the Duvalier government. And as Irwin will tell you, we remember very vividly in the cross-examination of Rudy Giuliani, who did, if you thought he was bizarre now, he's got a bizarre history that goes on for years. He not only testified in the case, he argued the case in the Court of Appeals. He went to the judge personally, and I know this only because I became friendly with Judge Spellman later on after the case was long over, and, you know, basically threatened him. So Giuliani's had a long history of doing what he's doing now. And in fact, in the Court of Appeals original decision, there's a footnote that said that Giuliani was lying, and mysteriously it was taken out of the final published opinion. But this became an international issue as well. Why? Because the US government was interested in continuing to prop up the Duvalier regime at the time. And so Giuliani testified on the witness stand that he spoke to the papal nuncio in Haiti, and he was told that there was no problem, people could go back, and there was, you know, nobody was fleeing persecution, etc. So one of the things we wanted to show was the US's collaboration in this. And just as a side note, I think for interest to the people listening to this, when I ultimately represented the democratically elected government of Haiti, the first thing I was asked to do was to try and recover the money that Duvalier and his wife had stolen. And to no surprise, one of the first things they did, and one of the first cases, you know, I would say of money laundering, was the Duvaliers bought an apartment in Trump Tower in New York. And so one of the things that we did is to try and seize the apartment in New York. And this was in 1991 after Jean V. Nelson. But it shows you the collaboration on both an economic level and a political level. And we were trying to bring that out through the testimony. And then finally, of course, was the issue of racial justice itself. And strategically, we made a decision to get back to your question. I'm sorry, Raymond, but to get back to the initial question, I think from a strategic point of view, we made a decision at the time not only to bring this on the APA, which is something that Irwin and Bruce Winnick, who may rest in peace, was one of the other professors I relied on, because I was a very young lawyer and knew nothing about anything at the time, other than that I wanted to try and do some good in the world. So of course I went to Irwin and Bruce, and they introduced me to the APA, which, by the way, I think our case was one of the very first cases where the Administrative Procedures Act was ever used in an immigration context. And so in that sense, it's very important. But then, you know, consistent with what we were trying to do as a matter of organizing and everything else, and bringing to the attention the racial injustice of Haitians, we decided to also bring the equal protection claim. And I'm sure Irwin will say we remember very vividly bringing all this evidence in, and we had statistical evidence in terms of how we approached the case. We had direct evidence. We had a statistician. We got the students at the University of Miami to look through all the parole files, because the government's position was, oh, you know, it just happened. It just kind of so happened that Haitians were detained and everybody else in the world was paroled. So we brought in a statistician, we looked at the files, and the statistician testified that the chances of Haitians being detained and everyone else being paroled in the way they were was the equivalent of flipping a coin and getting heads 1 billion times in a row. That's part of the testimony in the case. And then we found direct evidence, documents that said detain Haitians. They had a Haitian program designed solely for Haitians. Even though President Reagan was saying at the time, you know, facially neutral, you know, we're going to detain people, we're going to interdict people, and we're going to expedite their removal, the only people who that was done to were Haitians. And we were able to prove that satisfactorily. And what happened was interesting. Judge Spellman was a very smart man, and I think a very great judge. And he realized, because of all the national pressure, he wasn't going to rule in our favor on the discrimination issue, because he knew it was such a hot button issue. So instead, he released everyone under the APA. But as Irwin said, when it went to the Court of Appeals, the Court of Appeals looked at the evidence and basically said, you got to be kidding. I mean, the evidence was so overwhelming on the question of racial discrimination that they pointed to Gamillion versus Lightfoot, you know, the very famous gerrymandering case involving racial discrimination in the South. And they said, this is as stark a case as Gamillion versus Lightfoot in discrimination. And then, of course, the case went en banc in the 11th Circuit. And the 11th Circuit, of course, did not want to touch the facts at all. They basically ignored all the facts and said, simply as a legal matter, the Attorney General could do whatever he wanted to do, in essence. And that was the case that was presented to the United States Supreme Court. And, you know, to show you how high profile this was, the Solicitor General himself argued the case, which was not always typical in the Supreme Court. And the government tried to dodge the bullet, and they did it, of course, with the help of Justice Rehnquist and a majority. Only Justice Brennan joined Justice Marshall in the dissent. And, you know, as a young lawyer, I just have to tell you this story, and I think I told this to Raymond. I looked up, you know, in the Supreme Court, you're very close to the justices, right? So I'm a would-be civil rights lawyer, and I look up and I go, wow, that's Justice Marshall. That's Justice Brennan. You know, it's like, it was quite an experience being able to argue in front of them. And, you know, our argument was an interesting one, which is we said, even though the president and the Attorney General had said that this was facially neutral, in fact, lower level government officials had discriminated based on race and national origin. And I kept mentioning race. They didn't want to deal with race. They always tried to kind of turn the case as a national origins case where they felt they could do more. And I think Justice Marshall's dissent at least brings that issue head on. He does mention race, so I think that's really why the case is so important. It's a case where somebody is finally saying, yeah, this is a matter of race and national origin. It's not just national origin. And it's inconceivable that you could ignore the fact that all the Haitians are Black. And the bottom line was it was clear in how they treated Cubans versus Haitians that it was a stark case of racial discrimination. And I think as we now know today in case after case and what the Legal Defense Fund is doing and what we tried to do in Saget in New York and Ramos case, we did the same thing in Saget. We said, look, if you look at what Trump has said, it's a matter of racial discrimination. He was very blunt about what he was trying to do. So this case was very important, I think, is the initiation of that process. And
Thanks so much for that. Thanks so much for that, Ira. And thank you so much for kind of contextualizing the litigation within the broader campaign. And so I want to bring Ninaj into the conversation to talk about the role of activism and community organizing in all of this, and how the work that folks did surrounding Jean kind of parallels the work that folks are doing today. And you alluded to the TPS cases, and I think that's also true in the other immigration programs. So Ninaj, can you talk to us a little bit about that?
Sure, Raymond, how are you? So the work that was done around Jean versus Nelson totally parallels the work that's being done today and the years throughout the 80s, 90s, leading up to today. And mainly in the way that we find ourselves as whether activists, community organizers, lawyers, litigators, working collectively for one goal to fight racial discrimination. And as Ira said, race is in the center of it all, whether we're looking at it back then and looking at it today in the TPS movement. During Jean versus Nelson, what led up to it, basically, it was people on the ground in the community in Miami, the Haitian community in Miami, whose family members were being detained in Chrome, where Chrome was like created, especially for the Haitian refugees when they were coming in. It wasn't even a detention center before that. It was like some sort of a
Nike missile base.
Yeah, exactly, aimed towards Cuba. And so they bring in the Haitian folks in there and they treating them terribly, as we see again happening in Guantanamo 10 years later, as we see happening today on the border at Kearns and Berks County and all the different places that we have Haitian families and children being detained today in 2020. It's like Jean versus Nelson paved the way for a lot of activism, both in grassroots organizing and litigation, but it's like we're going through a cycle that keeps coming back, and that's happening today. I think, as I was saying in the 80s, these were family members that were walking into Haitian Refugee Center, much like we see today, walking into Haitian Women for Haitian Refugees and other organizations in Florida like FUM and their organizations, Haitian organization in San Diego as well, Haitian Bridge Alliance. People are walking in. These are family members that were walking in saying, my family members are detained and this is what's going on. And meanwhile, the Haitian Refugee Center was dealing with regular individual representation for asylum seekers, much like we're doing today in 2020. And so going through the 80s, that led to another round in the 1990s when Haitian Women for Haitian Refugees was founded in 1992 after the Jean-Bertrand Aristide, the first democratically elected president in Haiti, was overthrown. And there was a lot of Haitian refugees leaving by boat and being interdicted. As Ira mentioned, Rudy Giuliani, he was the person who actually drafted the interdiction policy in the early 80s, and a treaty actually that was signed by Jean-Claude Duvalier, which allows the US Coast Guard to interdict Haitian refugees on international waters, which is basically an arrestation. And what they would do in the early 90s in Guantanamo or on the waters is arrest these folks, bring them up on the Coast Guard cutters, burn all their belongings. You know, imagine you left knowing that you're leaving to apply for asylum, and you bought your most important papers and your whatever belongings you can carry. They would bring them up and they would burn them on the pretense that there's some microbes or so that they don't want to bring in. And then they put them in these detentions in Guantanamo. At the time, I actually went down there as an interpreter working for the Justice Department, and I met the co-founder of Haitian Women for Haitian Refugees, Marie-Lily Segat, who was also an interpreter. And it allowed us to be in a place where we could see firsthand the arbitrariness of these proceedings that were going on. They had pulled inspection officers from the border and some asylum officers from different offices throughout who knew nothing about the country conditions in Haiti, and to make this judgment, to have these credible fear interviews, to make this judgment of whether or not this person was an economic migrant or if they were a political refugee that would be allowed to continue into the US to apply for asylum. And the reason that they ended up opening this detention in Guantanamo, which seemed to me to be like a concentration camp. People were behind barbed wire. Families were separated, much like we saw families separated back in Chrome in the 80s, and much like we see families being separated today in 2020, detained with their children and separated from their children, spouses being separated from each other, still going on today. And there were a lot of other atrocities. There were documented cases of military, US military people raping Haitian women in Guantanamo. So they were subject to a lot of human rights abuse while they were seeking asylum in Guantanamo. This led to, there were actually about 40,000 Haitian refugees in 1992 to 1993 that came through Guantanamo to seek asylum as they were fleeing the persecution of the US-led coup in Haiti, and US-backed coup in Haiti, I should say. And when they were screening, they had these screening sessions with credible fear interviews. They repatriated about 3/4 of them and allowed about 25% of them to come in, somewhere between 10,500 and 11,000 people. There were different numbers out there to come into the US to apply for political asylum. There were about 100 and something Haitian refugees that were found to be HIV positive. And they created this HIV camp for them in Guantanamo. And where they had these 100 and something refugees together with their family members, they ended up being 268 people total, being guarded by 300 Marines, 300 US Marine soldiers in this refugee camp, as if it was some sort of prisoners of war, where these are asylum seekers, you know. And it was supposed to be a humanitarian mission, but here they are with 300 Marines guarding 268 refugees. And there was a lot of abuse because there was activism from the refugees themselves. They had hunger strikes, they held hunger strikes, they organized themselves, they got in contact with legislators and the media in the United States. And eventually there was some litigation on their behalf where there were lawyers from Center for Constitutional Rights. There were ACLU folks. There were human rights lawyers from the West Coast. There were some corporate firms that also worked on this case, HCC, against the government, Haitian Centers Council. And there were also law school students from Yale Lowenstein Human Rights Clinics that were very much involved, directly involved, going back and forth Guantanamo. And some of us were also going back and forth to Guantanamo working with them on this case. But it was really amazing how the refugees themselves really took charge of their situation and had these held actions on the base that were heard here, and there were groups of students on different campuses here that were working together. They were because they were HIV positive, Haitian people were always targeted. It was one of the stereotypes that this country has against Haitians. They're known as boat people, HIV carriers, and at the time there was not enough research on HIV, and there was this ideal, the 4 H's, people that had HIV: homosexuals, hemophiliacs, heroin addicts, and Haitians. And so there were all sorts of organizations that came out to protest and in solidarity with the refugees that were protesting for the self-advocating in Guantanamo. And this was being worked alongside with the litigation that was happening in the court in Brooklyn. And so over the years, we see, eventually they were released, but over the years, we see the same parallels as we saw back with Jean versus Nelson and around this case that I described in Guantanamo, one of the cases. There's so much litigation over the years on behalf of Haitian refugees, and the cases are always based on fighting against racial discrimination. And we can fast forward to today when we're working around the TPS, the folks that have temporary protective status. When Trump was campaigning for presidency initially, one of the first things he said he was going to do when he got in office was to reverse these executive orders. And indeed, as soon as he got in there, he terminated DACA and TPS, these executive orders that were done by the Obama administration in the immigration area. And what that caused was normally when people were granted, when a population from a certain certain country is granted TPS, they're on different circumstances, whether it's for natural disaster or some kind of warfare or man-made disaster. They're at different times. And so we were all working in our prospective communities, the TPS holders and the populations that have TPS. But once once Trump came in and he terminated TPS, same difference, right? He terminates TPS. Now he terminates TPS for all these 13 countries, and organically we all come together, whether it's the Haitians, the Salvadorans, the Hondurans, the Nepalese, all the countries, the Nicaraguans, all the countries that terminated TPS. We come together, and now we're fighting as a big bloc. There's a movement called National TPS Alliance that's led by TPS holders, and brought up one of the many TPS litigations right now that we have today, the Ramos case, that allowed some TPS holders to stay in status to this day, even though since 2017 the Trump administration moved to terminate TPS. So you see the same parallels of the activists or community organizers working, whether intentionally initially with lawyers and litigators, or at least at the same time with the same goal, but collectively with the same goal to fight against racial discrimination. We saw that then, and we see that today. Other parallels that we saw, some of the things that Ira mentioned, and was with the difference, the disparities that you saw, and the blatant differences that you saw in treatments of the Cubans and the Haitians in the 1990s when we were in Guantanamo. Even after the HIV positive refugees were allowed to come in, there was another round of Haitian refugees that came in 1994. There was about 16,000 Haitian refugees. This is when Bill Clinton had first become president, and they kept flipping the policy. He had campaigned to go against the Bush policy, but once he came in, because of pressures that he got from some Republicans, mainly Jesse Helms, he ended up making it even more difficult for Haitians to get refugee status or asylum status. So they started this in-country processing that didn't work, only about 1,000 people compared to under Bush, the 10 or 11,000 people that came in to apply for asylum. There was only about 1,110 people that got refugee status then. And then they realized the human rights abuses were so great in Haiti, it was impossible for people to apply for refugee status within Haiti. So then they moved the operation to the US Comfort ship off of the coast of Jamaica. And then when people were coming through there were so few people coming because it was so windy. They had to come through the Windward Passage by boat. So they thought they could handle it. And there was only 1,500 people that came out in 2 weeks. But then when the winds calmed, suddenly 16,000 people came out. Then they changed the policy again. You couldn't apply for refugee status, moved everybody to Guantanamo, reopened Guantanamo Bay Detention Center for Haitian refugees. And then they stopped the process to allow them to apply for asylum or refugee status, and said it was going to be a safe haven camp. They're going to stay there indefinitely until democracy is restored in Haiti. And during this time, in the US media, the mainstream media, we're hearing stories about Fidel Castro attacking people that are trying to leave Cuba. And much like in the time of Mario Boatlift, the Castro administration says, hey, anybody want to leave? Leave. And suddenly 50,000, within a month, 50,000 Cubans came out by boat to Guantanamo. Now, previously, when the Haitian refugees were in Guantanamo in 1992 and 1993, occasionally you would see like one boat of Cubans come across from the other side of the island, and the next morning they would be flown to Miami, and they would get this Cuban Haitian status that Haitians were no longer getting. And then 1 year later, they would be able to adjust to permanent residency. But because 50,000 people came out at once from Cuba now, this is in the summer of 1994, precisely August of 1994, and the Haitians had been sitting there, 16,000 Haitians had been sitting there for 2 months, perhaps it would have looked like way too blatant for them to bring these 50,000 Haitians around, the 50,000 Cubans around the Haitians in Guantanamo that had been sitting there for 2 months, and allowing them to the US like they normally brought in Cubans. And then it would have posed another problem, whereas more Cubans would have come out if they had let the 50,000 Cubans in as they usually did. Now they had to start some kind of diplomatic relations with Cuba, just to at least get an in-country process set up there to stop Cubans from coming out by boat. And they iced it back to Haiti quickly, and then they started bringing the Haitian 16 on a Saturday. He was back in Haiti, and 3 days later they started bringing in the 16,000 Haitian refugees and brought in the 50,000. Once they were out of Guantanamo, they brought in the 50,000 Cubans into the US and resettled them as refugees, where 1 year later they would be able to get permanent residency. So we see these disparities, throughout the decades. And we also see, again, the mixture of community organizers, activists, lawyers, litigators, working together, and even legislators in some point, not by choice, but by force. Because again, I remember in 1998, when many of us had worked hard to pass the Haitian Family Reunification, not Haitian Refugee Immigration Fairness Act. This was simply because NACRA had just passed for many Central Americans. And in Miami, the Haitian community, a lot of undocumented people, took the streets because they felt left out of NACRA. And they went in crowds of 5,000 to 8,000 people and stood in front of their legislator's office. It was, again, a time when Senator Jesse Helms was saying he doesn't want to see a piece of Haitian legislation, and he was very powerful then. Because they stood in front of these offices and these legislators didn't want these crowds in front of their offices, they started writing legislation on behalf of the Haitian refugees. And from there, throughout the country, we built a movement to push it through until finally, a year later, it didn't even take an entire year for the Haitian Refugee Immigration Fairness Act to pass, allowing 50,000 Haitians that were out of status, which included the people from Guantanamo that had came in the early 90s who were trying to who were stuck in this backlog of asylum that we still have today in this country. And that allowed them to get permanent residency. We see parallels between that and the situation now with the TPS holders that have a movement and have several litigations, including the Ramos case that I mentioned, but also that covers several TPS holders from different national. But also you see specifically that there are several pieces of lawsuits against the government now on behalf of Haitian refugees in particular, including the NAACP Legal Defense Funds, which Haitian Women for Haitian Refugees was a plaintiff on that case, the Sage versus Trump cases. There are at least 3, I believe, that are specifically geared towards Haitians with TPS based on fighting against racial discrimination, because they wrongfully terminated TPS there's so much evidence that it was for reasons of race. And even in the Ramos case, you see that one of the bases is racism that they have in that case, and also in the fact that they were U.S. citizen children of the TPS holders that you're not protecting if you're threatening to take away their parents. So we see today, the difference is today, I mean, when we look back at Jean versus Nelson and the activism that was going around it, its situation is similar, but I think a lot of that happened organically when, throughout the 90s and 80s and 90s and leading up to now. But today, I think we find ourselves intentionally and strategically organizing around litigation, such as in the case with TPS, because these cases are allowing the TPS holders to stay in status so that they can continue to self-advocate for themselves to find a permanent solution. And that's how all of that is working well together.
Thank you so much for that, Ninaj. Thank you for drawing the connection between the work that the folks did during the time of Jean and all the wonderful work that we're seeing now. And I'm glad you mentioned Ramos and the TPS litigation, because panel 2 is going to feature some of the lawyers who are involved in those cases. So I'm really excited to talk to them about the work that they're doing now and how that again relates back to the work that was happening in the early 80s at the time of Jean. I'd love to bring Muz into the conversation now to kind of expand on the efforts to bridge the gap between the traditional civil rights community as we understand it and the immigrant rights community at the time. Muz, can you talk to us a little bit about that?
Sure. Thank you so much, Raymond, for having me among the giants of the Haitian refugee story in America. I was actually a pretty minor player in that chapter of our history, but so proud to have been part of it. And before I delve into the role that I was part of, let me just highlight for young lawyers and law students who are listening to this as to how important this litigation was to the development of immigration law and practice. I had just gotten into the immigration bar. And if you talk to people at that time about how do you make a strategic lawyer, they'll tell you, oh, make a good relationship with the district director, or find a time when the examining officer goes to lunch and nab him on his way to lunch, or find out when they go to the bathroom to see you could nab them in the bathroom. There was only the Haitian litigation that introduced the power of federal litigation to the immigration bar. I mean, Ira mentioned the administrative procedure. It was not just that. It was just using litigation as a tool to achieve your role, which for the first time, I think for a lot of us became apparent in the context of Haitian litigation. And also, I think just the power of that litigation. I distinctly remember him starting number of those conversations with Judge King's opening statement of his case. And that this is a case that represents millions, I'll get this wrong, millions of Haitian refugees, poor Haitian refugees, the persecution of the government and the indifference of ours. That encapsulated for a lot of young lawyers the reason why they become lawyers. So for a number of us who entered the field at that time, we're frankly following the coattails of Irwin and Ira and Rick Swartz and Peter Shays of the world to see immigration sort of practice in a different way. Now, my entry to this was accidental. I was a lawyer in the American labor movement. I was actually a lawyer for the International Ladies Government Workers Union, which was a union that had been founded by Jewish immigrants at the turn of the 20th century. And people think of unions today as bastions of pro-immigrant movement. It was just not the case then. Unions at that time were clearly in the restrictionist column in the immigration debate. And so our job was to see, how do you convince American labor unions to become champions of Haitian refugees? And that sort of became one of the organizing principles of what then became the National Coalition for Haitian Refugees and later called the National Coalition for Haitian Rights. We were proud to house the National Coalition for Haitian Refugees at our union office in New York. And it was important to us because we didn't see this necessarily as an immigration issue. We saw it centrally as a civil rights issue. I did not used to do immigration work then. I was a lawyer negotiating contracts, for blouse makers and skirt makers in New York City. And suddenly this became an issue which just was impossible for the union to turn a deaf ear to. And so we thought this has to become a cause we had examined. So the goal initially was to convince other unions in the country and eventually the AFL-CIO. And then when the coalition was formed, it was principally to broaden sort of the voices speaking in defense of the Haitian refugees. And the organizing principle was just straight, blatant racism of that chapter. It just was hard to avoid, especially from what we've heard from others, just the sharp contrast of how we were treating Cubans. That was very important backdrop to the whole Haitian story. So the coalition was formed. It was a very low budget, very scrappy, but in my sort of experience, an incredibly effective organization at that time. The coalition was chaired by Cardinal Bevilacqua, a major figure in the Catholic Church. Its vice chair was a prominent civil rights leader called Bide Rustin. And it had all major unions, including the AFL-CIO in it. It had all the prominent civil rights organizations of the country, from NAACP to the Urban League. It had all religious organizations, from Presbyterians to Episcopalians to the Catholic Church to the Lutherans, even the evangelicals, and all the important Jewish organizations in the country at that time. And then we brought on Hispanic leadership. That we thought Hispanics were just beginning the call for immigration reform. And we thought it was important to bring that sort of strand in the immigration debate into the Haitian debate, and prominent Hispanic leaders became part of the coalition. And then in a very extraordinary stroke of luck, Hollywood became part of the coalition. Jonathan Demme, who was a very prominent movie director at that time, had spent time in Haiti, and he decided to embrace the cause, and he was a very active, vocal member of the coalition. So this was kind of disparate voices normally bringing together on a cause. And so other than the broad coalition that it was clear to the coalition early on that litigation is an important tool, but it's not the only tool that is going to get us to the success. So sort of the breadth of the tools that we involved became one of the exercises of the coalition. So people mentioned Jean Jules. Jean Jules would pack the courtrooms in Miami with supporters, but the same people would then travel in buses to the Hill and pack the hearing rooms. And you could see why hearing rooms became very effective with people were talking and sort of campaigning from their personal experiences. Same then became important for us to talk as a communication tool to the press. I mean, those of you now think the press is always pro-immigrant, and the New York Times writes 5 editorials a week on immigration. It was so hard to get one editorial in the New York Times and I remember distinctly a time we got both the Wall Street Journal and the New York Times to editorially ask for a change in the policy towards Haiti. It felt like a coup, but we knew how important sort of communications was. And to sort of beat it all, when you have a press conference where Susan Sarandon and Meryl Streep is present together with Jonathan Demme, you suddenly all of us get kicked back to the back of the room. So it sort of became another sort of very important organizing tool, not only to make, as I used to call the Haitian cause popular, but also chic. I mean, I think the Haitian issue was the first chic immigration issue that many will recognize. And I think today, many of us have benefited from that. I think the last point I want to make, I know we should have audience sort of chime in. We wrote the amicus brief that the coalition submitted on the Jean case, and I was privileged to work on this with Mike Hooper, who we shall not forget. Mike Hooper was the executive director of the National Coalition for Haitian Refugees. It was his extraordinary charm that brought many of us to do unreasonable things at all hours of the night. He was a force of nature. Mike died very young at the age of 41 of melanoma. But he sort of, brought all of us together. And part of that was Mike and I and one of our distinguished friends and colleagues, Wade Henderson, who was then at the ACLU and then became head of the Leadership Conference in Civil Rights. I think one of the most prominent African-American lawyers to enter our field. We co-wrote that brief, and that made only 2 points, essentially. One was the equal protection point that all our litigation colleagues have made. The other was the policy point, that look, in the arc of our history, we have slowly but systematically gone away from removing vestiges of racism, that we got rid in the 1965 Act from the vestiges of racism of the 1924 Act. We got rid in the 1980 refugee law, the vestiges of racism in our refugee law, that this is just a reversal of that trend, that we are going back to introducing racism in our immigration policy, and that's sort of inconsistent with sort of the historical development, which I think is really important, a point for people to remember as we look at immigration in the historical context today. And that was an argument, by the way, we used very compellingly in the only time, or the first time the Haitians, because Ninaj corrected me in the HERFA, the first time Congress did something for the Haitians was in the context of the 1986 immigration law when we passed the Cuban Haitian Adjustment Act. I was glad to lobby that act, and I think we would not have been able to make that argument if we hadn't rooted it in the historical disparities that we had witnessed in the Haitian issue. Thank you.
Thank you so much for that, Muz. And we are getting close to the time for audience Q&A. So I want to make sure that I articulate the CLE code for this panel, and the CLE code is orange, as in the color. So please note that on your CLE affirmations. The code for this panel is orange. But before we turn to audience Q&A, I want to bring Irwin back into the conversation to ask you kind of about the nuts and bolts of actually putting together an equal protection claim at the time. I work on equal protection intentional discrimination claims at the Legal Defense Fund. And as anybody who's worked on those cases can tell you, they are exceedingly difficult to bring. Kind of the nuts and bolts of showing intentional discrimination on the part of a state actor or the federal government is a very serious undertaking. So Irwin, can you talk a little bit about how you and your team went about putting together the equal protection claim and the intentional discrimination claim?
Well, to begin with, we got the judge to allow us to help the INS do statistical work. So I convinced the judge that 20 University of Miami law students could be sworn in to help as special, advocates. So the government didn't like that much, but they allowed it. And they counted the statistics of the INS, whether they came through on the airport or on boats during particular dates. Then to prove not only disparate impact, but intention, we had a statistical expert, as Ira suggested to you. He actually was a professor at the University of Miami, and he computed through a variety of different statistical methods the possibilities that what the government did was, what they did in regard to treating Haitians differently was either on the basis of chance and not intentional. And as Ira said, he looked through 3 separate categories, and in each of the categories, he said the chance of being Haitian and being incarcerated with non-intentionally was 1 in 10 billion in one case. All of them were statistically significant. Another was if you flipped a coin, I think 1 billion times, I think that's what they said, it was clear that, that there was discrimination. And the only dispute as to that is the government said, oh, we didn't intentionally discriminate. That was all the proof they ever put on. And then we took a whole bunch of other factors. We had information from, and as Ira might tell you, actual documents from the government, which showed that they intentionally discriminated from high government officials, which I don't think you'd ever be able to get today in any of these kinds of cases. We also showed the history of discrimination against the Haitians because we had a slew of cases we had litigated, which showed that they treated the Haitians differently in a discriminatory manner regarding work permits and a whole variety of other things. We also had the Civiletti case, which just came before, which found that in deportation hearings, they did the same kinds of things. We had government officials who testified who worked at Chrome, that Cubans were being treated better than than Haitians were. We had the former INS general attorney, who was at that time, I think the most famous person in immigration law, who testified he'd never seen any other group treated in such a discriminatory fashion in all the years he had been an attorney. And we had other lawyers who represented different categories of people from different countries who testified none of their clients had ever been treated in this manner. And so we just had a wealth of evidence. It was so overwhelming that the government really couldn't dispute it, and they didn't. And so then on appeal, the appellate court, the 11th Circuit said, this is incredible. If this case doesn't prove discrimination, there is no case that could prove it. While the Supreme Court made it difficult to prove intentional discrimination, there were a bunch of factors, each of which, as I was suggesting, that we used and followed through on, and there was nothing they could do to rebut it because it was their own testimony, it was their own documents, it was their own officials, and it was their own treatment of other groups vis-a-vis Haitians. So in a way, when you look back, I can't even imagine that we'd get that kind of information again, in kinds of cases. So I want to mention one other thing. When the case got to the Supreme Court that I argued, the Solicitor General was making his first argument as Solicitor General. His name was Rex Lee. And through Rehnquist's questioning, he came to the conclusion, I better not argue the constitutional issue. Rehnquist said, isn't it true that these statutes are neutral on their face, and therefore they cannot be applied in a discriminatory manner on the basis of nationality, essentially? And he jumped on it and said, oh yes, that's right, even though they had argued different things below. Yes, if a statute is neutral on its face, it can't be employed in a discriminatory manner. And so there's no need to reach the constitutional question, which I think is another reason, and that's how they decided the case. I think it's another reason why Justice Marshall decided to write that amazing dissent for two reasons. One is he wanted to rebut that, but two, he knew that the government would say that and they would pass a number of statutes that were not neutral on their face. And then we couldn't use that as a statutory sort of non-discrimination argument. And so he said, the only way of dealing with it now is to get to the constitutional question. So he was pressing in those days. We didn't think that was such a good idea. We were sort of happy, but now that we look back at it, he definitely, that opinion is incredibly important for those reasons. And I'm sure, as Ira can attest, in the immigration context, a lot of statutes are not neutral on their face. So
wonderful. Ira, can you talk a little bit about why, like what the big deal was about the dissent? So we've been organizing this conference for a very long time. We were actually supposed to go forward in April, but things were postponed. And the question that keeps coming up is, what's all the fuss about? I mean, it's a dissent. Who cares about dissents? Can you talk a little bit about why that dissent is so important? But before you do, we're actually getting questions in the chat about the code for the CLE code. So let me repeat it. It is orange, as in the color orange. Hopefully that came through loud and clear. But Ira, please.
Okay, just two things to follow up first to what Irwin said. You know, one of the reasons why the evidence was so overwhelming is that you had a much broader concept of discovery than you do today. You know, over the last 40 years, through the courts and through pressure, I think, from various organizations and government attorneys, they've narrowed the ability to get discovery. I mean, I took Rudolph Giuliani's deposition. He was the Deputy Attorney General of the United States. I took the deposition of the Commissioner of Immigration at the time. We got the document that President Reagan had actually signed off on saying, you know, detain the Haitians, interdict the Haitians. That kind of evidence just doesn't come out anymore because they won't allow you to have that kind of discovery. And that's a big issue that we as civil rights and immigration rights lawyers should really think about, which is how we can try and broaden the basis for discovery, because over the years, they've really rewritten the discovery rules to make it virtually impossible to get evidence to prove your claims. And then on top of that, they have said you must prove the claim when you file your application, right? You have to, when you file your petition or you file your complaint, you have to show great detail as to what the claim is about discrimination. And of course, before that, you only had to, you know, it was notice pleading, and then you could get discovery. So we're kind of getting it from both ends, where on the one hand, you're not getting the discovery, and on the other, they're saying, well, you're supposed to have all that information when you file your complaint, and, you know, in the various Supreme Court decisions. So why was the dissent so important? I think it was so important because of what we said at the beginning, which was, this was really the first case where the federal government, other than employment discrimination cases possibly, the first case where the federal government was being challenged on the grounds that the federal government itself was involved in racial discrimination and discrimination based on national origin. It was the first case that went up to the Supreme Court where the issue of racial discrimination in immigration took place. So this dissent became so important because it was the first time that in the Supreme Court, that justices of the Supreme Court, and of course Marshall, you know, being who he was and being as important as he was, you know, kind of being the clarion call here of talking about why this was a case about racial discrimination and why it was wrong in immigration. And, you know, the importance of it, just from an immigration point of view is, and even Justice Marshall walked the fine line in the case, recognizing that immigration has always been considered different in some sense. That is, that the government has greater latitude in immigration than they may have in other fields. And that has been historically the case for over 100 years. But here, you know, Justice Marshall took that on directly. He said, whatever those boundaries are, it can't involve racial discrimination and discrimination based on national origin. That even in immigration, there are restrictions. Even in immigration, there are limitations. And those limitations certainly involve issues of racial discrimination. And I think that's why it's such an important dissent, because it's set for really the first time in a major way by a major figure, Justice Marshall, saying that racial discrimination was impermissible. After all, the Haitians were the first group in the modern area. We obviously had people coming from China, Asian immigrants who were discriminated against, but they were often discriminated against based on the statute itself, that the statute said that they could discriminate, the Asiatic barred zone statutes and so forth, the national origins quota system. But here was where the government was saying, oh no, we're facially neutral. And we were saying, no, this is institutionalized racism. It permeates the system. It goes down to the lowest levels of immigration officers, and that is impermissible. And I think that's the full force of why Justice Marshall's opinion is so important, because it focused on you can't discriminate when you're claiming that, racial neutrality. You don't have, just like in any other area. And that was one of the arguments, by the way, I made in the Court of Appeals, saying even if in education, even if education isn't a fundamental right, even if coming to the United States isn't a fundamental right, that doesn't give you the right to discriminate based on race. That equal protection is different. You could say that there's no fundamental right to be released from detention. And of course, that was the government's claim. And, they pointed out the Mazzei case. And, Justice Marshall talks about that in the dissent. But even if there's no constitutional right to be released, you still, just like there may not be a constitutional right for education, you still can't discriminate based on race in education, in how you detain people and so forth. And I think that was the power of the dissent.
Can I add one thing? As for the Haitians themselves, the power of the dissent was they are to be seen as human beings and not just objects that the government can deal with in any manner they want. So that is really the power of the opinion.
That they were persons within the meaning of the Fifth Amendment
Constitution, and they must be treated like human beings.
So along those lines, we have a great question from the audience. It's kind of a question about where would we be now had the equal protection claim found success at the Supreme Court instead of the majority having avoided it? Where do you think, what difference do you think that would have made?
Well, I'll just answer it briefly, and I'm sure everybody else has the same thought. I mean, in the Trump era, you can imagine how powerful that would have been in a whole variety of things. I mean, Trump has made a change in immigration law every single day that he's been in office. 99.9% of them have been horrible. They've been racist. They've been discriminatory. Having that as a majority opinion would have been an enormous weapon to use.
Yeah, absolutely.
Muz, what are your thoughts about that?
Well, you can't add much to that. I think almost everything that you can think about in immigration policy today, you could use the equal protection claim, whether it's the travel ban, which is what he started his administration with, whether frankly, all that's happening at the border today.
Yeah.
I mean, the discrimination at the border on the basis of national origin race is just too blatant. And in this case, it's also a violation of international law, which is also reasonably close to what we had seen in the Haitian issue. So there may have been interdiction on the high seas in the Haitian case, MPP, metering, transit, they're all consistent with the regime. And I think the equal protection claim would apply to all of them.
Thank you so much for that. And unfortunately, we are out of time. I'd love for this conversation to continue for a little while more, but I'm afraid that Zoom is not as easygoing. So I want to thank all of you for sharing your stories with us and for sharing your insights with us and for sharing your insights with us. I am forever grateful for the work you did back in the early 80s, as I'm sure a lot of others are. So thank you.
Thank you.
Thank you for having us. Appreciate it.
Thank you so much, Raymond. And thanks to all of you folks.
Thank you.